So the third component of the OPH model is setup and structure. All right, setup and structure, third component. This is where basically we're going to walk through. Again, this is where you seek legal advice, seek accounting advice. But I'm going to walk you through the structure that you should really consider using regardless of what country you're in, because it is designed this way specifically to limit your liability, limit the liability of the people involved in the process, as well as protecting your money, you personally, all of that stuff. So you really you should consider using the structure. Obviously seek legal advice, but the documents themselves is really the only thing that's going to change from state to state or country to country. Would be the actual contracts or documents themselves is what would actually change, but about the only thing that would change. All right, so, wrong button. There we go. So the structure for a lease option, sandwich lease option, if you recall, it looked like this. Leasing, the owner gives you a lease, gives you an option to buy, and that's called the lease option. You put two lease options together, and you have a sandwich lease. So if you remember this from yesterday, this is the basic model for a lease option or sandwich lease. So we're going to break this down a little bit further and just talk about what you would need to make sure is in the various documents. Okay. Oh, that I did not want that to happen. It's supposed to come in. Let me bring up. It was all supposed to come in individually. That's just way too much stuff. Fortunately, I did this training before, so I have a different slide. Where I think I can get it to come in. No, it comes in the same way as well. All right, so I thought I had that would come in component by component. Okay. So we are going to start on the left-hand side, sorry, on the right-hand side. We're going to start on the far right-hand side with a picture of the home. You can see hopefully you can see my cursor. Here we have the homeowners, okay? Remember in the model, we had the homeowners, we had you in the middle. And you in the middle is being represented by these two companies, which I'll get into a little bit further. And then we have the tenants on the other side. Okay, so from the middle, the two companies to the homeowner, that's one lease option. From the middle, the two companies to the left, the tenant buyers, that's another lease option. Okay, so the whole thing, this is a sandwich lease option. Okay, so I'm just going to start with the top company. This is the option company. So this is the company that would hold the option contracts. Okay, so the only thing that this company is used for is the option agreements for this particular deal. It does not, it's again, not a lawyer, not an accountant. Seek your own legal advice. What I'm showing you here is currently how I set up and structure my own deals for my own business. You should speak to an independent legal advisor in setting up deals for your business. And whatever I say should not be interpreted as me telling you what to do. Okay, that's my disclaimer. I should be protected in case anybody tries to sue me. All right, so setting up my option company. So this option company does not do business with any outside entity. It only holds contracts between the company itself, which, I am one of my other companies is a shareholder. So I control this company, full ownership control. So this company has an option agreement with the homeowner. Okay. And then the same company has an option agreement with the tenant buyers. So the homeowners give me the option to be able to buy the property in the future. And I, in turn, give the tenant buyers the ability to buy the same property in the future. Okay. So that is the only thing this option company does. This option company does not hold any money. It does not have a bank account. It does not do any daily activity. The only thing this company is used for is as the representative on the contracts. That is the only thing this company is used for. It is the option, the representative is the option representative when doing the agreements. So, okay. So it's the company that represents me for doing the option agreements between the two parties. So you can see I'm going to the right, from the option company to the right, to the homeowner. We see that this is so this company would have the option with the owner. So that's one agreement, option with the owner. Like I said, considered the most powerful contract in real estate. I consider it that because it gives you, maybe I will buy it, maybe I won't. I have the options. I have my escape. I can do whatever I want. Now, the second agreement that this company would have with the homeowner is what's called an acknowledgement and waiver by owner. So this agreement basically says that the homeowner recognizes that the option company and the option company representative advise them that they need to seek legal advice or talk to an attorney about reviewing the documents. So remember I said, I tell the homeowner, yeah, these contracts been through thousands of lawyers, one more is not going to hurt. And the homeowner takes the contracts, reads them themselves and says, I'm not going to bother going to see a lawyer. It all looks good to me. Well, I don't want this to come back in court and say, well, that guy never told me to see a lawyer. He just gave these to me and told me to sign them. So I want the owner to sign a document stating that he was advised of his rights to seek legal advice. He was told to go seek legal advice, and he chose on his own accord to not seek legal advice. So that is what this document does. It protects you should anything ever happen in the future and the owner claim he didn't know what he was signing. Okay? Now, this next document is the irrevocable direction to pay. Okay, so when this sale actually takes place in the future, the sale it used to be in the old days, there used to actually be two transactions take place at the same time. They called it a double close or a simultaneous close, where the option company would actually buy the house from the homeowner at the exact same time that the tenant buyer buys from the option company. And those two closes would happen at the exact same time with the same lawyer. That used to be what happened way back when, but banks have tightened up on that, and it's they don't allow stuff like that much anymore. So what we've decided is in the wording in the contracts, but the option contracts, it states that the sale of the home, the option contract between myself and the lawyer, or between myself and the homeowner, states that I am acting on behalf of a third party to be named later, and the sale of the home will be to a third party to be named later. Well, guess who the third party to be named later is? It's the tenant buyers who has an option on the to buy the home. Now, because I have one price with the homeowner and a higher price with the tenant buyer, remember, that's the spread. That's the spread I'm making the money in. Well, I need the homeowner, because the sale is going to take place directly from the homeowner to the tenant buyer, bypassing me altogether. These agreements are worded in a way that the sale actually takes place between the homeowner and the tenant buyer. Now, if that was the normal case, the homeowner gets all of the money. But remember, I have my spread in there. So in order to protect myself and to make sure I get my spread, my money, I need the homeowner to sign this irrevocable direction to pay that says, I agree to pay option company all monies above this certain value, which is the value that the homeowner agreed to sell the property to me. So any monies collected above this value goes to the option company. So that irrevocable direction to pay advises the lawyers that anything, let's say my agreement with the homeowner is $250,000. I agreed to buy it from them, and I'm selling it to the tenant buyers at $270,000. So that $20,000 difference, the irrevocable direction to pay would say, hey, anything above $250,000 gets paid to the option company. So when the lawyers close the deal, selling the home from the homeowner to the tenant buyer, that $20,000 goes to the option company. Okay, so that's what the irrevocable direction of pay document does to protect you. And there's also an addendum to a purchase contract. So, for you investors that have done investing, you've bought properties or you've filled out your standard real estate purchase contracts, you always have your terms and conditions in there, or your subjects, or maybe you do an addendum with all of your clauses that you want in for the purchase. So we have an addendum to the purchase contract, which is very specific for options. So that is another document that we have between the option company and the homeowner. So we have those 4 different agreements. Okay. So now we're going to go from the top so then that option company, a question came in. If you have any questions on any of this, just feel free to ask as I'm going through it, because it's going to be a lot of information. So how is the option company and property management company set up? Is there paperwork to register these? Yeah, these would be in Canada. It's basically you go to a registrar, you pay, I don't know, $700-800. You can buy just numbered companies off the shelf at your local registry. So I buy 1, 2, 3, 4, 5, 6 Alberta Limited or Alberta Inc. or Limited Inc. really is irrelevant in Canada. It's just whatever you feel like calling it. Just a standard numbered company. You can just buy it off the shelf. And basically they just ask you a few questions. Who's the director? Who's the president? Who's going to be the shareholders? Blah, blah, blah. You just answer them and get the company. Or you actually go to a lawyer and you say, I need 2 companies set up. Here's the purposes of these companies. One's just going to hold contracts. The other one's going to be an active corporation that does business and pulls in money and gets money from other people. Again, seek legal advice. Talk to a lawyer about setting this up. I would advise do not do any of this as a sole proprietor. You do not have to get these corporations until you have a homeowner that has agreed to the first deal. As soon as the homeowner agrees to say, yeah, I agree, let's get together and sign these contracts. I reviewed the contracts. They look good to me. Let's sign them. So when the homeowner says that is your cue to go register 2 companies. You do not want to do any of this in your own personal name as a sole proprietor. And there's a couple of reasons. One, well, there's lots of reasons. Because you need to have 2 separate entities One entity looks after the options, and one entity looks after the leases. Doing it in your own name, you're opening up yourself, your family, everything you've ever worked for to liability, where they can come after you if they ever sue. When it's set up through these corporations, the only thing they're going to sue is the option company. And remember, the option company is completely broke. It has no assets. It does not do business with anybody. They cannot access or gain access to shareholders or directors or presidents. The only thing in that company is a piece of paper that's an option. So they can sue that option company all they want. They're never going to get anything for it. Replace that option company with you, and they sue you, they can get everything you've ever worked for plus whatever. So never do this as sole proprietor. You can operate without having a company right up to the point where you got your first homeowner that says, hey, I'm ready to sign these contracts, like let's meet tomorrow. Then you say, okay, well, I'm not available tomorrow. I need a couple days. And then during those couple days, you either go register 2 companies yourself, or you go talk to a lawyer and say, I need 2 companies, toot sweet, to register to do up these contracts. Okay, back to the option company. Now we're going to deal with the tenants. So said option company has a different option agreement. The option agreement with the owner is completely different than the option agreement with the tenant. They are not the same. Option agreement is not the same wording. These 2 option agreements, all these agreements work in conjunction with each other, but they are not the same. They have to be, the wording and everything is completely different. Option with the tenant and certificate of legal advice, basically that's similar to the owner, where the tenant has said that you told the tenant to seek legal advice, that whether they did or they did not, they're going to sign this document saying that they did seek legal advice, and here's the lawyer that they talked to. Or they did not seek legal advice, but they were advised to seek legal advice by the option company, but they just chose not to at their own free will. Okay, so those are the 2 agreements that the option company has with the tenant buyers. Now you notice that between the option company and the property management company, there's something called an option management agreement. Now, remember, I said the option company is broke, does not even need a bank account. But if we go back to the examples where the tenant is giving you like $9,000 as an upfront option payment, and they're paying an extra $200 a month as an option payment that goes towards their down payment. Well, technically that money and all of that is documented in the option agreement. Technically that money should be going to the option company. But the option company has a management agreement with the property management company that says, hey, property management company is going to look after all of our financial transactions. So they will be collecting all of the option money on behalf of the option company. So all checks or deposits that are to be made to the option company should be made to the property management company, hence keeping the option company broke, and the tenant buyers or the homeowners will only sue the option company. The only thing they can sue for is the option, and that company is broke. So there's nothing they can technically get out of it. So the property management company on the bottom. Now the property management company is your active company. This is the company that actually does business. Money comes in, money goes out. It pays trades, it pays the homeowners, it collects money from the tenants. It does all kinds of activity. It's really a liability company. And this company typically is owned by another company that the money would go up into that company. But that is, again, for your accountant or your lawyer. So the property management company has a lease with the owner. And that lease basically abides by the Landlord and Tenant Act, or whatever governing body you have in your city or state or country that looks after the relationship between a tenant and a landlord. So the lease basically, it doesn't matter what it says in the lease, because that governing body has full control, but basically it outlines the arrangement, the term, the amount that you're going to pay. If you can extend the term, like we have an automatic 12-month extension. So if I want to extend the term with the owner has no say. I can just say, I'm going to extend it by 12 months. There's nothing you can do about it. So that is the lease with the owner. And then that property management company has a sublease with the tenant buyer. Remember, that lease with the owner has a clause in there that enables me to sublease. So between the property management company and the tenant buyers, we have a sublease. Obviously, different phrasing, different contracts altogether. And then you also have your move-in, move-out inspection. Now, we have a homeowner's manual we give them. It's about 100 pages long. It contains all of the agreements, plus their inspection, plus so many other documents. So it's basically about this thick, 100 pages or so. We make it into a binder and we give it to the tenant buyers, and they're going through that. We're going through all of those pages, getting them to sign all of the agreements, contracts, plus the move-in, move-out inspection, plus all these other documents that we go through with them. So it's basically the manual for getting into this agreement. It's quite hefty. So typically you don't get too many shysters that will go through the whole process that we put our tenant buyers through. So people, when they see that much documentation, many contracts, all those hurdles up front, only the truly serious people are going to enter into this type of arrangement. So the property management company has a sublease with the tenant buyer and a move-in, move-out inspection, which you go through. And when you're signing the documents with the tenant buyer and you're doing your move-in inspection, I take my phone or a camera with me, and I either take hundreds of pictures of the entire place, every wall, every ceiling, every fixture, inside the appliances, you name it, I'm taking pictures, or I do a video. So I know that what every square inch of that place looks like, and where every little ding and stain and scratch and everything is in that entire place. So if I ever, if they chose not to exercise their option to buy, and we had to do a move-out inspection, I have visual proof of what the place looked like when they moved in, and it should look in the same condition, less normal wear and tear. So they're not going to pull anything over on me to say, oh, that hole was there, or oh, that burn was there on the carpet, or whatever. No, I have video evidence and picture evidence of every square inch of this place, so you can't pull that crap on me. Okay, so those are the agreements that the property management company has with the tenant buyers. So there's a couple other things going on in this document. If we look at the very top right corner, you see we have caveats. Well, in these types of arrangements, the banks and the lenders want to see that the individuals with the option truly have an option and have it registered against the title. Now, unlike a purchase agreement, when you actually have a purchase contract, like if you did agreement for sale or subject to, you actually have a purchase contract, you can register those purchase contracts against the title of the property. Now, with an option, you can't register the option, but you register a caveat, and that caveat indicates that you have the option to purchase the agreement, purchase the property. So the option company goes out and it registers two caveats. The option company registers the caveats. It registers one caveat on behalf of the option company, and it registers one caveat on behalf of the tenant buyer. So you might be asking yourself, well, John, why don't you just get the tenant buyer to do it? Well, the person that registers the option is the only person that can release the option. So this happened to me before. I had a tenant buyer register a caveat on the title. They did not exercise their option. And then I had to try to track them down And this whole process took 6 months. I couldn't track them down. We had to go through the legal process and all of the hurdles in order to attempt to track them down, do all those things, try to find them, notify them. And we had to prove to the court that we couldn't. And only then would the court grant an order for our lawyers to go to the land titles and have the caveats removed. So never allow the tenant buyers to do it. You do it on their behalf. You tell them you're doing it on their behalf. And as soon as it's done, you provide them with a copy of it so they can rest assured and feel confident that they're being protected against, their rights are protected and their option to buy is registered on title. So you do that, and if they end up not exercising their option to buy, then you are the one that can go and just easily remove those caveats. Okay? So we'll just go a little bit through some of the agreements and what the agreements should have in them. So agreements with the tenant. It's a sublease with the tenant, and that's between the tenant and the property management company. It follows the resident tenant regulations of your province or your state or your city or your country, whoever governs the body. The leases follow those guidelines. The leases do not want to reference an option to purchase agreement or purchasing it at all. It just strictly wants to reference the lease. And there's another reason why we put them in two separate companies because typically the lease, if you have a lease with one company and an option with a separate company, those are two separate entities. That's like somebody having a lease with me and somebody having the option with Malik. We're two different people. So I can go and act, if they're screwing up on the lease, I can take them to the tenant board and say, hey, you're messing up with their lease. And it's independent of the actual option. So the tenant board should hear me. But you'll find a lot of cases as soon as they bring up that, they say, I have an option on this property. They say, the option's not with me. It's not with my company. And you might be able to get the hearing through the tenant resolution board, or they just may defer the whole thing to a court. But in the lease, regardless, you do not want to reference that the verbiage in the lease does not want to reference an option at all. It just strictly wants to talk about the lease. So the option with the tenant is between the tenant and the option company. It follows the laws of your country or your province or state, any property acts, whatever governing body that's ruling over you, wherever you reside, it's going to follow those guidelines, which is why I advise to seek legal advice. Florence wants to know if the case of removing a tenant. If you need a tenant removed, you go through the process with the landlord and tenant board, and I also advise starting a statement of claim with the courts as well at the same time. I've never had to go, in all my years, I've never had to actually have somebody evicted because I do my very best of screening right up front, and people come in with money. And they know the situation. They know the lay of the land. You don't pay, you got to go. They're well aware of that. They don't ride it out with me. And so I've never actually had to go through that process. But you take the lease, you file a claim at the landlord and tenant board as soon as possible. But you might as well go to the court and start a statement of claim there because there's a good chance it could get referred there anyway. So you don't want to waste the time for the tenant board to say, hey, you got to go to the court anyway. So make sure it follows the laws of your jurisdiction, wherever you reside, the country, the city, the state, province, whatever it is. Make sure the option, your lawyer is following those guidelines. In most cases, the option money needs to show as being refundable. That's what the lenders want to see. That's what the mortgage insurers want to see. But I can tell you this right now, if the money was technically refundable, we would not be doing this business. Just because the contracts say it's refundable doesn't mean it's actually refundable, because the contract also states that should they not exercise the option, then we as the optionor suffer liquidated damages. Meaning we were counting on, we went into this agreement because they said they were going to buy the place. They didn't buy the place. Now I'm going to have to suffer with vacancies, selling costs, getting it show ready, fixing it up, commissions if I have to sell it. So very quickly we can provide documentation that says that is way more than their option, the option money that they paid. So it is very easy to not pay the option money back. And I tell everybody, again, I do my very best to try to get people not to go into a rent down with me, because in doing that, they in doing that, they're well aware of the situation. So I say, you know, it says that they're refundable, but guess what? If I got to get you out, like, you're not going to get any money back just because it says refundable. It also says we're going to suffer liquidated damages. I'm going to suffer liquidated damages, my company. The owner is going to suffer liquidated damages. So between the two of us, the amount of money that we can charge you for not exercising this option is far more than what you're actually going to pay us in option money. So you're not going to get anything back. I just want you to know that. Like, that's the risk you're going to take, is the liquidated damages. I'll tell you right now what they're going to be. They're going to be vacancies. They're going to be repairs. They're going to be sales commissions to a tenant or a realtor. They're going to be my fees. Because I still got to get paid, because it's, you know, I'm acting on behalf of the owner. I got to get paid too. So all of that far outweighs the amount of money that you actually put into this thing. So you should just be happy that I don't sue you for the money you owe me for not going through with this. And so I tell people this and they still sign. So they're very well aware of what they're getting into and what the repercussions are if they don't exercise their option. That's why I don't have any issues when people are getting divorced or they lose their job and they know that they got to go. They're not expecting any money. They know it's better for them to just leave, and they do. So that's the option money. We also get the tenants to, in their own handwriting, write major points of the contract. So we have areas of the contract, like, where we would get them to write 5 bullet points, and those 5 bullet points would be the major emphasis of the contract. Basically says that they know that they're responsible to pay the rent on time. Otherwise, they could be evicted based on the regulations of the Tenant Act. They know that they have to keep the home in good condition, stuff like that. But we get whatever the main components of the lease are, we get them to write it on the contract. We have a section for it where they actually write it. So we know that they understand it because they've actually written it in their own words, and that if it ever goes to court, we show the judge, hey, they understood this. They wrote it in their own handwriting. Independent legal advice, that is between the tenant and the option company, to make sure that, remember, that they were advised to seek legal advice. If they did so, They would name the lawyer. If they didn't, they indicate that they were advised to, but they just chose not to. And then document the numbers the tenant buyer needs to know. So just basically how much the rent, monthly option, initial option, the dates of when they need to exercise their option by, just all of that information on one little sheet. Handwritten script, the move-in, move-out inspection, which is between the tenant and the property management company. And like I said, take tons of pictures or a video. I never give them to the owner. Because the owner does, technically the owner is supposed to do a move in, move out with me, but they never do. And I never give the owner any documented proof of what the place looked like before I took possession. Florence asks if they do not pay on time, is the monthly dollar not applied to the mortgage on their behalf? So there's two components, Florence. There's the rent component, and none of the rent is allowed to be applied. Rent is rent. It's just like paying rent in a rental place. But there's the extra monthly payment, which is over and above rent, that's collected every single month. So if they do not pay rent on time, technically you do not have to, they still have to pay that option money, but technically you do not have to allocate that option money for that month to their down payment. And actually, if they don't pay rent on time, they technically they forfeit their option to purchase the property. Now, I'm not a bad, I was gonna, there's many words I was gonna say. I'm not like that type of person. If they're just late on their rent once or twice, I'm still gonna sell them the place. I'm still gonna give them the credit for that money. Like, I'm not an a-hole by any means. But technically, as per the word of the contract, I don't have to give them credit for that money, and nor they've also defaulted on their option to purchase the property. So technically, I could get out of it if I had to with them, but I'm not like that. I'm in the business of getting people to, helping people sell houses, helping people buy houses. So if somebody's late once or twice on their rent, it's not the end of the world. But I'm very strict about the policies, and I tell them, if you're late, you forfeit your option. Oh, I was doing that. Sorry about that. All right, now agreements with the owner. So we have the lease with the owner. That's with the property management company. Same thing, follows the tenant regulations in your area, city, province, country, state, whatever. That does not reference the option contract at all. You have an option with the owner, which is between the owner and the option company. It follows all the rules of your country, city, state, province, whatever is relevant. Again, seek legal advice. Acknowledgement and waiver, basically stating the owner states that they were told to seek legal advice. Power of attorney. I do this. I've encountered situations where the owner of the home is an immigrant, and they are going back to their country. So you take the risk of them not coming back when it's time to sell the property. So in that case, I'll get them to meet with my lawyer, and we'll sign a power of attorney that allows me to do only one thing, and that is to close on the sale of this house as per the contracts that we have agreed upon at the point in time when it's set to sell. So I can't do anything. It's not like a power of attorney if you have over a family member because they're ill, they're not able to fend for themselves, or they're incapacitated or something. This is very limited, and the only thing you can do is just close on the sale of the home in the absence of the owner. You can't make any changes to the agreements. You can't do anything other than just close on the sale. That's it. That's all you can do. And it's only in extreme circumstances if the individual is, the individual is going to be out of the country. I do it, Ali, you do it in your own personal name. So you personally would have the power of attorney. I believe it has to be in a personal name. Like I said, in case the owner, in case the owner changes their mind, but I only use it if the owner I know the owner tells me that, and I've had this in the last 2 or 3 months. It's like, yeah, we're going back to our country of origin for said period of time, or they don't disclose when they're coming back. It's like, okay, well, here's the situation. I can't, in good conscience, enter into these agreements knowing that you're not going to be in the country, or if you're going to come back to the country. So the only way I'll enter into this is you need to sign a power of attorney just that only grants me the ability to close on the sale of this home at the end as per the terms of this contract. That's the only thing I can do. I can't change the terms. I can't change anything about the agreement. I can't do anything other than just make sure that the sale goes through. And so the lawyer sends you your money, and I can just make sure that the tenant buyer can buy this home. That's the only thing I can do. I can't really expand on immigrant. That was just an example because I just had owners of houses wanted me to lease option their home, and they told me that they were they weren't going to be in the country. They were going back to a different country. So when I say immigrant, they told me they were an immigrant. They came to Canada from a different country. They live here legally. They own property. They have jobs, but they're just going back to their country of origin. And they say that they're going to be there for years, or they may not be coming back. So technically, if they're not in this country, they can't sign the documents to sell the home. So the only way that to sell the home is somebody has to act on their behalf. So I get them to give me like if they're an immigrant that's in the country right now, they're going to be in the country. They have no reason to go home. Then there's no reason to do this. I only do that when they just outright tell me that they're going back to whatever country they came from, and they don't know when they're going to be back. That's when my red flag goes up, and it's like, I need a power of attorney. Other than that, I never even bring it up. No, Ali, no conflict of interest, because all you can do is just close on the sale of the house. You can't do anything else. There's nothing you can do other than just make sure that the sale goes through. You can't change anything. You can't change the dates. You can't change the price. You can't change where the money goes. All you can do is just say, because somebody has to be there to sign the document to sell it from the owner to the buyer. If the owner's not there, they need a representative, somebody that has the authority to sign on their behalf. And that's usually done with a power of attorney. So you just want to make that power of attorney you. That's all you can do is just sign. And the lawyers do all this. So again, just talk to a lawyer about this. If it ever comes up, you only do this if you know the person is not going to be around. Don't approach this because it's very limited. And if it was ever we don't bother doing it if the people are around. So if the situation, I don't want to spend a lot of time on this because it rarely ever happens. So there's no sense in spending a lot of time on something that's, 0.1% of chances of it ever happening. But if it ever comes up, just know that you need to seek legal advice. That's all I'm going to say. Seek legal advice. So do you sell or get rent to own? I'm not sure what you're referring to. What happens if circumstance changes in the middle of the tenant term? Do you get this form in most cases, recent rent term flex? Again, this is not for tenants. This is only for owner. If the owner of the home has told me they're going to leave the country, that's the only time this comes up. So I don't want to spend a lot of time on this because it is so rare that an owner says, oh, by the way, I'm leaving Canada and I'm not coming back, or I don't know when I'm coming back. That's the only time this ever comes into play. It's never for a tenant, ever. If the owner is not born in the country, they came from a different country, but they do not express to you that they're going to leave the country that they're in, it never comes up. But if they come out and say, yeah, I'm going back to country X because that's where I'm from, and I don't know when I'm coming back, that is the only time. When they say those words to me, red flag goes up. Okay, well, if we do this, I need a power of attorney to execute on the sale, and we have to talk to a lawyer. That is it. Yes, that is the only case, Florence, if the owner tells me they're going to leave the country. If they don't tell me they're leaving the country, I assume they're Canadian or whatever country. I assume they're here. But if they come out and say, yeah, I'm going back to this place and that's where I'm originally from and I'm going to be there for a few years, or I don't know when I'm coming back, red flag, I need a power of attorney. We got to talk to a lawyer. Otherwise, pass. Move on to the next house. Don't even bother. You're going to waste your time, put yourself at risk. It's not even, most of the time, just move on. Just move on. Forget about it. Just say, I can't help you because you're not going to be in the country. Sorry. Move on to the next house. That's all I would do. Just move on. Forget about it. Sorry, can't help you. I only deal with people who are going to be in the country. That would be my answer. If you don't like, for something that happens so rare, I'm spending too much time on this topic. But again, seek legal advice, talk to a lawyer. What would you do if? Long distance owners or investors, if they're in the country, it's not a problem because they can go to a lawyer in Canada and the two lawyers can communicate back and forth within the country and they can get the documents signed. It's only if they're in a different country I have an issue with. If somebody moves to BC, but they own the house in Edmonton, no problem. They can just go to a lawyer in BC to close on the documents. I don't care because we'd have them couriered to a lawyer there and then they'd come couriered back. That's okay. But if they're leaving this country that I reside in, not okay. All right, irrevocable direction to pay. Like obviously, you got to make sure that you're going to get paid. So you need to have that document. That's with the option company. Protects you to make sure that you get your share of the deal as the sale is set up to be directly between the owner and seller. So that's, we already talked on that. The irrevocable direction to pay. Addendum to purchase contract. A lot of these things I already touched on. So things to keep in mind for your lease agreements, that it follows all the provincial state regulations. Get them to write on the lease that they understand the basic premise of the lease. So pull out the top 4 or 5 bullet point, like the lease. I know that I understand I have to pay $1,900 a month in rent. If I am late on rent, I can be evicted as per the regulation, the tenant board regulations, blah, blah, blah. They keep the place in good condition is one of the things you could say. If they don't pay, they can be evicted in accordance to the whatever law, the provincial state law, that they're not allowed to store things on the property. So those are some of the things that you might want to put in there, get them to write in their own handwriting, that they understand these things. Things to keep in mind for your option agreement: follows the Property Act or contract law of your province or state. Option and lease can't be in the same name of the owner. Like that's something that is very specific to my province, which is why we use two separate corporations. And then we just made it, it just makes way more sense because we like to separate our assets from our liabilities. So the asset being the option company, the liability being the property management company, because that's the one that does all the activity with all the different companies, people. So we keep our assets completely separate from our liabilities. So we'll always do two separate corporations. Even if we're in places where we don't need two corporations, we'll always do it because it limits our liability as individuals. It protects our assets. It protects our money. Also protects the individuals and the parties involved. Option and lease must be separate documents. Do not try to put a lease option in one document. I still hear of people doing like a all in one document, a lease and an option. It's just bad news. Option contract must show the option money is refundable, as we talked about that. Get them to write on the option agreement that they understand the basic premise of the let's just say premise of the option, not of the lease. That the repairs are their responsibility. So I understand that I'm responsible for all ongoing repairs and maintenance of the property up to $1,000 per instance, for example. I understand that if I am late with my option payment, my option is null and void. And they understand that if they don't buy the property, they'll get a full refund less, a full refund of their option credits less all the liquidated damages. And those liquidated damages are going to total more than their option credits. And they understand that they must give option notice within 180 days prior to exercising their option. And that is the three components of the OPH model. So questions? Oh, I rolled through that. Seemed to go very fast, but God, I've been talking for 4 hours and 15 minutes already. Anybody have any questions? Like, so those are the three components of the OPH model: the attraction, the presentation negotiation, and the setup and structure. Okay.